Good day, esteemed viewers. My name is Chinedum Okochi, a law graduate of Ebonyi State University, and of course, I'm super excited to be a graduate intern at HARLEM Solicitors. Today, as part of my primary assignment as a graduate intern at HARLEM Solicitors, I will be presenting to you an interesting lecture on the topic Regulation of Telecommunications Interconnection and Network Assets in the Nigerian Telecommunications sector. You can agree with me that interconnection has enabled you and I to freely connect and communicate with our friends in different parts of the world. Thus, by the end of this lecture, you will understand the concept of telecommunications interconnection, its various forms and parties, laws governing interconnection in the Nigerian telecommunications sector, how interconnection takes place, and finally, the essence of interconnection in the telecommunications sector. So, stay tuned and stay connected to the end of this video. Being an MTN user, I have always been amazed as to how I was able to place a call across to my mom, who is a Glo user. And at the same time, I was able to connect and communicate with her, despite her network or distance. It might interest you to know that this was made possible as a result of interconnection between the two different telecommunications networks, which enables me to freely connect and communicate with my mom despite her network or distance. The question which calls for an answer is, what is interconnection? The word interconnection is derived from the prefix inter, which means between or among, while the noun connection refers to the relationship in which a thing or an idea is linked or associated with something else. In general, interconnection refers to the act or process of connecting two or more systems together for the purpose of facilitating communication, data exchange, or resource sharing. However, by virtue of Section 157, which is the interpretation section of the Nigerian Communications Act, ACA 2003, defines interconnection as the physical and logical linking and connections of communication systems used or operated by the same or different operators in order to convey messages to and from the respective systems for the provision of services. A simpler definition: interconnection basically implies the commercial and technical arrangements by which service providers connect their equipment, network, or services to enable their subscribers have access to the network or services offered by another service provider. In telecommunications, interconnection can take place at various points in the network, such as at the physical layer, data link layer, or network layer. This brings us to the two forms of network interconnection, namely one-way interconnection and two-way interconnection. One-way interconnection is where one telecommunications operator must obtain interconnection from another licensed telecom operator to offer services to its subscribers. A perfect example of this is where a smaller operator that does not have their own network infrastructure, the law provides that they must rely on larger operators in order to provide connectivity for their customers. While two-way interconnection refers to where two or more operators must connect their networks to enable subscribers on one operator to communicate freely with subscribers offered by other operators. Such interconnection is extremely important and necessary for customers of one operator to communicate freely with customers of other operators. This is because it ensures seamless connectivity between the different networks. Having understood the concept of telecommunications interconnection, it is important for us to understand the laws and guidelines that governs interconnection in the Nigerian telecommunications sector. To regulate telecommunications interconnection, various laws and guidelines have been established. Specifically, Section 70 of the Nigerian Communications Act (NCA) 2003 empowers the Nigerian Communications Commission, which is the independent national regulatory body governing telecommunication in the Nigerian sector, to make and publish regulations and guidelines for the effective functioning of the Nigerian telecommunications sector. While Section 99 of the NCA 2003 grants the NCC the power to make interconnection regulations. Such regulations and guidelines include: 1. Telecommunications networks interconnection, hereinafter referred to as Regulation 2007, the guidelines on procedures for granting approval to disconnect telecom operators 2012, the guidelines on technical standards for interconnectivity of networks, and finally, the guidelines on international gateway access and VoIP over internet protocols. In addition to these subsidiary laws, Sections 96 to 103 of the NCA 2003 provides an extensive coverage on the interconnection of telecommunications networks. Having been familiarized with the laws and guidelines that governs interconnection in the Nigerian telecommunications sector, it's important for us to understand how interconnection takes place in the telecommunications sector. It might interest you to know that the reason why I was able to connect and communicate with my mom despite the network or distance was not just because of interconnection. This was made possible as a result of the interconnection agreement between the two different telecommunications networks, which enables me to freely connect and communicate with my mom despite the network or distance. It therefore follows that it will be impracticable or impossible for me to connect and communicate with my mom in the absence of interconnection agreements. The question which calls for an answer is, what exactly is interconnection agreement? Interconnection agreement is a legally binding agreement between the requesting party on the requested party, which outlines the obligations and responsibilities of each contracting party with regards to interconnect services. It therefore follows that for there to be an interconnection agreement, the law provides that there must be a written request for interconnection from the requesting party who desires to interconnect its network with another licensed telecom operator. The law went further to provide that upon making such interconnection agreements, both parties must comply with the principles governing interconnection agreements. Such principles include: 1. Both parties must maintain transparency, neutrality, non-discrimination, fair competition, universal coverage access to information, equality of access, and equal terms and conditions, which is provided for in Section 97, subsection 1, paragraph A and B of the NCA 2003. However, upon the receipt of a request for interconnection from another licensed telecom operator, the law provides that the requested party has a statutory obligation to interconnect a telecommunications network with the requesting party at a technical feasible location. Thus, by virtue of Regulation 1, subsection 1 of the Interconnection Regulation 2007, it provides that every licensed telecom operator has the right and obligation to interconnect, and as well, they are free to negotiate the terms and conditions of the agreement, which must be in accordance with good faith, which is provided for in Regulation 1, subsection 1 of the Interconnection Regulation 2007. In addition to this, the law provides that both parties must maintain confidentiality of any information obtained from one telecom operator during the process of negotiating the agreement, which is provided for in Regulation 2, subsection B of the Interconnection Regulation 2007. Moving forward, the law provides that the obligation to interconnect cuts across all network service providers and network facilities providers. One of the things the law provides is extremely important and essential for parties to agree and determine upon making an interconnection agreement is known as interconnect rate or interconnection charges. The question which calls for an answer is, what is interconnect rate or interconnection charges? Interconnect rates are paid by each telecommunications companies for calls terminating on their networks. A perfect example of this is where a customer of one telecommunications company makes a call or sends data to a customer of another telecommunications company. The originating company, which is the company initiating the call, is required to pay a fee to the terminating company for using its network to complete the transmission. This fee is known as interconnect rate. Under the Interconnection Regulation 2007, it's proven that the NCC has the power to determine the interconnection charges, although that same regulation provides that parties to an agreement can also determine the interconnection regulation. However, the exercise of such right is subject to the provision of the NCC to set default charges, which is provided for in Regulation 6, subsection 1 of the Interconnection Regulation 2007. This brings us to the types of parties involved in an interconnection agreement, namely the requested party and the requesting party. The requesting party is a licensed telecom operator that desires to interconnect its network with another licensed telecom operator, while the requested party or dominant party, on the other hand, is a licensed telecom operator that has been asked by another licensed telecom operator to provide network to another licensed telecom operator. It's important to note that every interconnection agreement must be registered by the NCC by either or both parties, which is provided for in Regulation 98. This is provided for in Section 98, subsection 1 of the NCA 2003. Do you know that an interconnection agreement can be terminated? However, such termination leads to partial termination. Hence, partial termination refers to termination of interconnection services to specific locations, facilities, or services, and not complete termination of the agreement. The law provides that where a party desires to terminate the agreement, such a party must provide the other party with a 6-month written notice of its intention to terminate and must specify the grounds to terminating such agreement. Although, by virtue of Section 100 of the SCA 2003, it provides that notwithstanding the terms and conditions agreed by the parties to an agreement, a party shall not, in any time and in any circumstances, discontinue or disconnect any interconnecting party without obtaining a prior written approval from the NCC. Hence, the obligation to get the NCC's approval is provided for in the NCC guidelines on the approval to disconnect telecom operators 2012. Moving forward, or in summary, this lecture wraps up by providing you with the essence of interconnection in the telecommunications sector. Aside from the fact that it enables us to connect and communicate with our friends in different parts of the world, it promotes competition, it increases profitability, it promotes the efficient use of communication facilities, it protects non-discriminatory access, And finally, it facilitates capacity, sufficiency, and service quality. I know with this interesting lecture, you have been able to understand the concept of interconnection, its various forms and parties, laws governing interconnection, and the extent of interconnection. For more information, check out on our website at www.harlemsolicitors.com and do well to like and comment on any of our posts on Harlem Solicitors LinkedIn and Instagram page. Thank you.